Hi, my name is Damian Siwek. I'm a criminal defense and DUI attorney here in Los Angeles, California. The following video is a compilation of the top most common mistakes that people make when they've been arrested for a DUI in California. So if you have just been arrested for a DUI in California, please take the time to watch this video because these are mistakes you want to avoid. First is failing to recognize just how serious a DUI charge really is. Some people make the huge mistake of treating a DUI charge like it's just another traffic citation. In California, many traffic offenses are typically infractions. That means they're punishable by a fine only, and there's no probation and no jail time. However, at best, a DUI conviction is a misdemeanor. It results in a criminal record, the suspension of your driver's license, there's probation, alcohol classes you have to pay for, hefty fines, and up to a maximum of 1 year in county jail. So a DUI is nothing to take lightly. Number 2 is failing to appear in court. If you decide not to hire a DUI attorney, or you just can't afford to hire a DUI attorney, make absolutely certain that you still appear in person to your scheduled first court appearance. This is called the arraignment, and the date is noted on either your citation and or your bail paperwork. Judges absolutely hate it when people do not take their responsibility to appear in court seriously. Failing to appear in court will result in a warrant being issued for your arrest and very likely an additional charge of failing to appear in court, which comes with another hefty fine. Number 3, one of the most pressing things a person must act on is preserving their right to challenge the suspension of their driver's license. This is called the DMV's 10-day rule. So from the date of your DUI arrest, you have 10 days, including holidays and weekends, to contact your local DMV and request what is called an administrative hearing to challenge the suspension of your driver's license. Failure to act within that 10-day window will result in your driver's license being suspended automatically 30 days from the date of your arrest. Now, as I mentioned in some of my other videos, the DMV administrative hearing is a separate case from your criminal case. Whatever you do, don't just give up and take the suspension. It's your right to challenge it. By not even challenging it, you give the impression to the prosecutor that you have a weak case. So call the DMV or have your lawyer do it and request an administrative hearing and challenge the suspension of your driver's license, because after all, your ability to drive is on the line. Number 4 is representing yourself at your DMV hearing. This is a guaranteed suspension of your driver's license. In all my years of defending clients at DMV hearings, I've never once heard of somebody winning their hearing on their own. The odds are definitely against you here, and your best chance at fighting your suspension is with an experienced DUI defense attorney. Next is driving on a suspended license. If for whatever reason you fail to call the DMV in a timely manner and or your license gets suspended, do not drive. Now, I'm sure some of you are watching this and you're saying, well, how am I going to get to work? And my response is take the Metrolink, take the bus, carpool with a coworker, or if you're close, ride a bike or hail a cab. Now, I know some of these options are probably really inconvenient and they might even be impractical, but keep this in mind. Driving on a suspended license in California is a separate misdemeanor offense, punishable by heavy fines and or the imposition of jail time. You absolutely do not want to deal with this additional charge on top of your DUI charge. Number 6. Taking advice from non-attorneys. A DUI is the most common criminal offense, and we all know at least one person who's had the unfortunate experience of having one. As a result, there are many people who have their own opinions on how they should be handled, and they're more than happy to share their sage wisdom with you. The fact is, every DUI case is unique and complex, and the only advice that you should seek and listen to is that of an experienced DUI defense attorney. Number 7, failing to consult with a DUI attorney. California DUI cases are complex and technical matters that really do require the expertise of a qualified DUI attorney. I hear all the time from people that they just want to often give up because they feel that they're already guilty or someone has told them that they can't win their case. The truth is, there are numerous ways to successfully defend a DUI case, so there's absolutely no harm in seeking out a qualified DUI attorney and getting a detailed case evaluation, because case evaluations are always free. Number 8, hiring the cheapest attorney in town. When you begin your search for a DUI defense attorney to represent you on your DUI case, you will likely notice a huge discrepancy in what lawyers charge for their services. Some lawyers charge as low as $700 to upwards of $10,000. Now, you remember the saying, you get what you pay for? Well, that's absolutely true in the legal industry. Now, I'm not saying go out, break the bank, and hire the most expensive attorney, but be reasonable. Anyone willing to charge you an extremely low fee for their services obviously does not value the quality of their own work, and as such will not value you or your case. They will not fight for you. But for the same token, if somebody wants to charge you an arm and a leg, don't be afraid to ask them what their services will cover. Number 9, the district attorney is my friend and they are here to help me. Quite simply, prosecutors are not your friends. I know several prosecutors. Some of them are very collegial, very charming people. Some of them are good friends of mine. But the bottom line is, their job is to convict you. They see thousands of DUI cases every year and they will not give you a deal. They simply want you to plead guilty or no contest, so it gets that case off their desk. So as nice as some of them are, they absolutely do not have your best interest in mind. And finally, number 10, giving up and admitting guilt at your first court appearance. Don't ever assume that your case cannot be won. DUI defense is a very involved and complex area of law, and just because a person registers a high BAC doesn't mean the case is over. There may be certain defenses available to a person regardless of their breath test results. For example, was there a valid traffic stop? Did the arresting officer have a basis for the arrest? Was the intoxilizer machine that the person blew into, was it up to code and in working order at the time the test was administered? If the person submitted to a blood test, was the blood properly stored and preserved? Despite the facts of your case, don't ever assume your case can't be won, and consult with a qualified and experienced DUI defense attorney for your best chance at a great outcome.